next case is Cory et al. Versus Kathleen Waseleski et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I will be keeping track of the time. It looks like we have 2 appellees in this case. I believe my bailiff explained that you must split your time how you would like, and there's no rebuttal for you. The arguments are being recorded. When you present your arguments, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of minors, children, and victims during your argument if that's relevant here. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are. You may proceed.
Good morning. May it please the court, Jason Whitaker on behalf of the appellants. We would like to reserve 4 minutes, and with the court's permission, I would like to reserve some of my time for my co-counsel, Attorney Mascai, as well. Hey, good morning. We are here on a consolidated appeal of 2 issues. One is the court's granting of dispositive motions on behalf of the appellees, and then the second is the sanction related to one of those dispositive motions. Very briefly on the summary judgment and judgment on the pleadings issue, the issue with the defendant, appellee, MSRE, the inspector. From the appellant's standpoint, the whole case turns on whether section 4764-17C applies. The trial court did not reference that provision at all in its entry. The appellee's argument is that statute of limitations expired prior to filing the case, based purely on the date of the inspection and the date of the case filing. The statute of limitations is an affirmative offense for MSRE, and the position of the plaintiff's appellants was that they had notified the inspector within the 1-year time period of the deficiencies in the report, and under 4764-17C, it was on the inspector then to either decline to remedy, refuse the remedy, or actually remedy those deficiencies, and under 4764.
How did they notify MSRE?
Your Honor, I think by letter from prior counsel.
And is that something you argued to the trial court when the issue came up with statute of limitations?
Yes, Your Honor.
That was submitted on the record. This here's our letter we sent to them on such and such day.
Your Honor, I want to misspeak. I'm not sure if the letter was part of the record. There was, in the opposition to the motion for judgment, because that was Your Honor, that was a judgment on the pleadings case, and so the argument from the plaintiffs at that point was the pleadings don't establish whether or not that affirmative defense was met. We have the right to present evidence in the case, and so
Is it true that the complaint didn't reference that? Because it's judgment on the pleadings, we're looking at the 4 corners of the complaint, whether it's conclusory time barred.
I don't believe the complaint did address that issue, Your Honor. That, again, goes to the issue of it being an affirmative defense.
Conclusively time barred, sorry.
Yeah. From the plaintiff's standpoint, Your Honor, the issue is not so simple as here's the date of the inspection, here's the date of the filing. If the defendant argued affirmatively, in discovery, that issue would have all been fleshed out. But because the court granted judgment on the pleadings, that one went away. So, from the appellate standpoint, with regard to that, we believe that the court would, if the court imposed 4764-17C, again, that affirmative defense being the burden of the defendant, that in discovery all of that would have come out, but because the court ruled on the pleadings, that was a good point.
Well, counsel, I want to make sure I understand. So, you filed the complaint, and they moved to dismiss on the basis that, on the face of the complaint, it was outside the statute of limitations.
Your Honor, they filed a motion for judgment on the pleadings, yes.
Yeah, and in their argument, did they say on the face of the complaint it's outside the scope of the statute of limitations?
That's their argument, yes.
Okay. So, what did you file in return?
We filed a brief in opposition indicating that here's the statute, here's what the statute says. They have the burden on affirmative defense, and that the plaintiff should be permitted to conduct discovery and present evidence. That you can't essentially raise the statute of limitations on a motion for judgment on the pleadings if it's based upon extrinsic evidence like was it told by virtue of this back and forth?
Couldn't you requested to amend your complaint?
I could have, yes. With regard to the summary judgment, and this kind of dovetailed into the sanctions issues on the summary judgment, we believe the trial court did abuse its discretion in granting summary judgment, or erred in granting summary judgment on behalf of the estate. As to the legal issue of whether the as-is clause applies, no one disputes that the doctrine of caveat emptor exists, but there's ample case law cited in our brief in this district and in other districts that says if the plaintiff, the homebuyer, can show a fraudulent misrepresentation, then the doctrine's overcome. And so we believe the trial court erred in basically engaging in what the appellants would say is it's kind of an adjudication of the credibility of the witnesses.
So what piece of summary judgment evidence pointed to fraudulent conduct?
So there are two things, Your Honor. One, the expert report by Mr. Bovic, which he was never deposed by the defendant, the state. The estate never presented a counter expert. They used the Bovic report in their own motion.
So what specifically in that report talks about fraudulent conduct?
So the report specifically shows, for instance, I'll give you one example. In the basement, the engineer, Mr. Bovic, found a number of materials in the basement, caulking compounds, paint, and tied those components, those materials that he found in the basement, to what he deemed was extremely recent work to conceal what was behind those. So just to give one example. Another example was the issue with the roof, where he indicated that despite the disclosure form indicating that there was a small fixed roof in the rear of the home, that there was a larger active leak in the middle of the home, that the engineer provided analysis as to why he believed the plaintiff or the defendant seller would have known that. The court, essentially, the trial court essentially said that the conclusions in the expert report were, I guess, conclusory at that point. The court didn't accept that, and essentially, from the appellant's reading, said, if you're on notice of one defect, then by matter of law, no other defect can allow you to show a misrepresentation. And what came out in the sanctions motion was there was a hearing where one of the heirs of the seller who had died started talking about the disclosure report, and essentially admitted that there were inaccuracies in the disclosure report. So from the appellant's standpoint, this is, can the plaintiffs prove that those disclosures were knowing? And then looking at the expert report saying, hey, they actively used this to conceal, that was one of the plaintiff's theories in the case.
What was the other piece of evidence other than the expert report?
There was the affidavit of one plaintiff, Morgan Charles, Your Honor. There also was her deposition testimony, and one of the issues that appellants take with the way the trial court looked at both the expert report and her deposition was, I think the trial court only had excerpts of her deposition, and we believe the case law is very clear in that on summary judgment, when the trial court does not review the deposition in the full context, that the trial court doesn't actually construe the evidence most favorably to the non-moving party.
Did you argue that below?
Yes, Your Honor. Essentially, we argue that the solid work by the defendant's attorney, but basically confused Ms. Charles at her deposition into making a couple of broader statements than she had anticipated, which was, yes, we saw one step crack in the basement over here, but that doesn't mean that we knew about the concealed stuff over there. We weren't concerned about this little thing, but we ended up having to tear out our entire basement foundation and waterproof it in order to deal with this other issue that had been concealed. And so from the appellate standpoint, the trial court should not have engaged in what we would deem credibility assessments of Mr. Bovic's report and Ms. Charles' testimony as to whether or not they believe her statement of being confused. I'll turn things over to my co-counsel, but I just want to indicate that all of that is to say that to issue a sanction against the plaintiff and the attorney, first of all, as an attorney who filed this case, I'm not an engineer. Most trial courts, most plaintiff's attorneys aren't engineers, and to say that I should have challenged or somehow understood the technical aspects of recency and these caulking compounds is very difficult. So I'll turn this over to my co-counsel.
There's 5.5 minutes left.
I'll let you do the Your Honor, with regard to the sanctions, there's two issues. One is the legal conclusion part of it, and then the other part is the factual evidence. As the attorney who filed the case, I had access to the report. I mean, the testimony before the trial court was that the plaintiffs had procured that report before they'd even hired me. And so when most trial attorneys don't have expert reports before they even file a case, but we did here. The second thing is the chilling effect of the trial court sanction, which was to say, I'm trying to help these people try to file a case. I've got their statements upon which I'm relying, and those statements are bolstered by this expert report that says all of that. I'm not sure how I, as a plaintiff's attorney, would have been on notice as to the factual issues. And regarding the trial court's legal conclusion, it basically says that if the as-is clause and the caveat emptor doctrine apply no matter what, and so according to the trial court's position, there was nothing that would have reversed the caveat emptor provision, even though the case law in this district alone says to the contrary. To take the trial court's position, you have to basically throw all those cases out.
And you're down to 4 minutes and 10 seconds.
Okay.
You want to reserve?
I'm sorry, Your Honor?
You want to reserve that time?
Yes, Your Honor.
Thank you, Your Honors. I'd like to reserve 5 minutes if you're keeping track of time.
You don't get rebuttal, I'm sorry.
No, just for
Oh, you're saying to let you
Mr.
know in 5 minutes for your co-counsel.
for Mr. Winter,
For the
yes.
other counsel, excuse me. Go ahead.
Yes, thank
I will
you.
let you know.
So I want to first address some of the argument made by the appellants. First off, there was an argument that the affidavit of Morgan Charles and the deposition testimony of Morgan Charles, the full deposition testimony, wasn't presented to the court, and there was an assertion that an argument had been made to the trial court related to that. There is no argument related to that in the opposition brief filed by the plaintiffs, the opposition to the motion for summary judgment. I don't know when the first instance that was raised, but it was definitely not raised in opposition to
Did they raise that on appeal?
I'm sorry?
Did they raise that issue on appeal in their merit brief?
I don't know that for certain, but they definitely raised it now. Sorry, Your Honor.
And so just to make sure we're on the same page, when we look at the record, we're not going to find the deposition of Morgan Charles. The full deposition transcript.
I don't know if the entire deposition transcript was filed with the court. I don't know that as I sit here today. I do know, like I said, that issue was not raised at the trial court
But at
level.
the time, you're saying at the time of the summary judgment, you had not filed the actual complete transcript, you only filed excerpts.
Correct.
Okay, thank you.
And, just circling back to what this case is about, this case is all about evidence. It's completely about evidence, or rather a lack of evidence on the part of the plaintiffs. The summary judgment phase of litigation is a test of evidence. It's a test of facts. It's a test to determine whether there is a genuine issue of material fact. The estate, in its motion for summary judgment, laid out numerous, voluminous facts that showed that for every issue complained of by the plaintiffs, there was evidence that the plaintiffs knew about that issue prior to purchasing the home, or that they had an opportunity to view the home and see that condition. Mr. Whitaker just said that they have the VOVIC report, the VOVIC inspection, prior to filing the litigation in this case. And the Vovik report itself lists numerous conditions, with the foundation that are very readily apparent and easily observable.
Counsel, I just want to stop you. Let me ask you this question. You said this is all about lack of evidence. Isn't this case really about what they're alleging is that the seller fraudulently answered on the disclosure form, made false statements?
I think that yes, those are allegations that were made, but those allegations are unsupported, and that's why I say there's a lack of evidence, because...
You're saying they didn't meet that initial burden of, they didn't meet the burden of fraudulent conduct with their expert?
I don't believe they did, and I don't think the court believes that either, because if you recall...
I'm sorry, I have a follow-up on that. Is, if you're alleging fraudulent concealment, is the fact that there's an as-is provision relevant? I mean...
Absolutely, it is relevant, because there is case law, and I apologize I don't have it in front of me, but I cited it in my brief. There's case law that says a buyer of real estate cannot rely on a disclosure form that that is insufficient or otherwise lacking. They can't rely on that in the face of other evidence showing issues with the home or other issues.
And that's what I was going to ask you about, because it seems like a lot of the arguments you're making is not what the court ruled on. And the court ruled that that there wasn't a fraudulent statement, but it seems like what you're really arguing in your summary judgment or in your appeal anyway in response is reasonable reliance. In other words, fraud has to be a false statement, but then you have to demonstrate as a plaintiff reasonable reliance. And it seems like you're saying they couldn't rely on that statement because they had all these facts. Well, isn't that a different issue than we're looking at here today? It doesn't seem like that was actually what was argued to the trial court.
I think that's completely fair, that's an issue, but that's an issue that's outside of today. But I think they're all related, and the reason I say that the evidence is all related is because after presenting all of those facts in the estate's motion for summary judgment, rather than discussing the doctrine of caveat emptor, rather than providing the court with additional facts that would create a genuine issue of material fact, rather than doing any of that, the plaintiffs completely ignored that argument. They completely ignored...
What did you meet? How did you meet your burden? In your summary judgment motion, because it was your burden, what did you demonstrate to the court the reason why they could not prevail, that there was not a genuine issue of material fact?
Sure, it was all related to caveat emptor.
And so that goes to more reasonable reliance then, right?
Perhaps, if reasonable reliance is related to the caveat emptor.
Did you argue that there was no false statement that was made on the disclosure form?
I did argue that there
Did you
weren't.
provide any evidence of that?
Just the property disclosure form. The defendant was deceased at the time of the argument for the motion for summary judgment. But I don't believe that, again, that is an issue, because what the evidence that was shown to the trial court showed that prior to purchasing the home, the plaintiffs were fully aware of all of the issues that they complained of in their complaint. So since they were aware of those issues prior to purchasing the home, the doctrine of caveat emptor applies to forbid them from pursuing these claims. And it applied to grant dismissal of those claims on summary judgment. And again, the plaintiffs had an opportunity. They had an opportunity in response to present facts, present differing facts, present facts in support of their allegations, present facts that would disprove the caveat emptor argument.
And that seems to be what they're saying is, well, this individual, the seller, made these statements about the roof that were, if not false, at least misleading, because they only mentioned a small place in the back of the roof in the back of the house. I don't understand how it all works, but anyway, and there actually was horrendous things wrong with the roof itself. Now, in reply to that, what did you say? They say that creates an issue of fact whether there's a false representation.
Sure, in response to that, or in reply to that, we brought up the inspection by MSRE, and that is...
Doesn't that go again to reasonable reliance? I know I'm sounding like I'm beating a dead horse, but in other words, the statement can be false. Okay, you can show fraud, but you can't recover on it on the basis of there was no reasonable reliance. That doesn't negate that the fraud happened, I should say fraud, that the false statement was made. It just means that you can't recover.
I think that's completely fair. The court did not address the reasonable reliance issue, and that's why I'm not prepared for this, but I understand what you're saying, and yes, I agree with you that gets to that issue. But again, the MSRE inspection, in the roof section, it listed RR next to virtually all elements of the roof, which means repair or replace. And the MSRE inspection also called on the plaintiffs to conduct additional inspections of the roof. They were very worried about the condition of the roof, and the plaintiffs ignored that. They ignored that direction to get an additional inspection. They removed the contingencies, and they purchased the home as is. And that's the same with the foundation issues and all the other issues complained of in the complaint made by the plaintiffs. And so just quickly on the sanctions issue, that is how you arrive at sanctions and how the trial court arrived at sanctions. When push came to shove, they had no evidence to support their allegations. They couldn't point to any evidence to support their allegations.
I guess
There's 5 minutes left,
I'm sorry.
just to let you know that.
I guess I'll go back to beating the horse. If that's the case, the court, you just indicated, the court really didn't look at the reasonable reliance. So it seems like the focus went off was there actually a fraudulent statement made to begin with? And if there was a fraudulent statement made to begin with, then the court really didn't look at that. And how can we say then this is sanctionable whenever the first issue that everybody has to look at was there actually a fraudulent statement made was never even examined?
Well, I think the court did examine that just in the caveat emptor realm. You know, the court looked at that issue and the court said even if they were attempting to rely on this residential property disclosure form as a fraudulent statement, that evidence is belied by all of the other evidence that was readily available to them and that showed that no, the roof is not in great condition. No, there's water problems, there's mold problems in the house. All of these problems were brought to their attention.
So you're saying it wouldn't have mattered anyway. In other words, you know, if the court skipped over the first requirement of fraud, it didn't matter because there could be no reasonable reliance.
Yes, that's correct. And just on the other sanctions issue, you know, the caveat emptor, with all of that evidence in your possession prior to filing a complaint, we believe that no reasonable attorney would have brought claims for breach of contract in the face of the as-is clause, the doctrine of caveat emptor, and all of that. Thank you. And with that, I'll yield to Mr. Winter.
And Judge Lanziger, I have to make a disclosure before we proceed in regard to the dead horse. And I'm vegan and I don't even eat animals, so I'm definitely not going to be eating any liver. So I just want to make sure, since this is going to be broadcast all over the country and the world, that everyone knows that.
You have about 3 minutes and 5 seconds.
Thank you, Your Honor. Good morning. May it please the court. My name is Jason Winter, and I have the pleasure in this matter of representing Appley MSRE Home Inspection Services LLC. With the court's indulgence, I'll refer to that entity as MSRE for purposes of my argument. I'd like to begin by articulating the 2 principles which I respectfully submit should guide this panel's consideration of assignment of error number 2, which relates to MSRE. First, where on the face of the pleadings it is revealed that a claim is time-barred pursuant to the plain language of the applicable statute, and the plaintiff fails to allege any facts to support an inference that the statute of limitation is told, the court properly dismisses the action pursuant to Rule 12. In that regard, Your Honor, you had inquired as to whether the argument concerning this phantom letter was anywhere in the complaint and anywhere in the opposition to the motion for judgment on the pleadings. When you asked that question, to myself, I said, it's not
I
there.
understand why I asked it. I'm curious if it existed or not.
And I went back.
Does it exist or not?
And I read it again, and it is not there.
Okay.
That
That's my
argument
question.
is not-
I did not see it in the record anywhere. I know they talk about it. I didn't see it. That was my question.
So I
don't
wanted
see
to
it.
clarify that from our perspective. Secondly, Your Honor was correct. At no point did they move the court pursuant to Civil Rule 15A, which, as this panel knows, is liberally granted those motions to amend pleadings, to amend that pleading, to articulate any such theory or defense or facts. And so we proceeded in the trial court based upon that First Amendment complaint, which was completely devoid of any fact whatsoever, alleging that the statute of limitations, which is clear on its face, was told. The
So
second,
should courts award attorney's fees to the other party if it turns out on the face of a complaint it's conclusively time barred? I mean, is that what this stands for your part, for your client?
Your Honor, from the record, you may have observed that we did in fact move for sanctions. And the record, that motion was ultimately denied. The record would bear out that there had been extensive dialogue with counsel for the plaintiffs as to the time-barred nature of this. And
So your client didn't receive any attorney's fees at all?
we did not. Our motion was denied, and I do notice that we were relatively early in the proceedings, that we were extricated, and perhaps that played a role in that, I don't know. But it was denied. The second principle that I just quickly want to reference that I believe should guide the court is secondarily, where private parties enter into an at arm's length commercial contract with a clear, unambiguous, and reasonable term that delineates a time limitation on the assertion of a claim, such time limit should be enforced. And Ohio courts have long recognized that parties have the right to agree to that. Now, in this case, the court need not reach that issue. However, it is a secondary and I respectfully submit important principle to bring to the court's attention that there was in essence, backup here in terms of what the statute of limitations was that the parties agreed to.
Did your client argue that below?
It was briefed. It was not referenced in the judge's order, and I believe that Judge Rothberry did a very clinical job in terms of laying out the important dates and observations and paragraphs of the complaint and facts, and rather surgically goes through why this claim was time barred.
And you're out of time, so if you wrap up, please. In
Yes.
10
So respectfully, I ask that the court affirm the trial court's grant of judgment on the pleadings, and I thank this panel for its time.
You have 4 minutes and 5 seconds.
Thank you, Your Honor. Frank Mazguy here on behalf of the appellants. First of all, I guess I would say we are not disputing. We have no claim under the contract due to the as-is clause for caveat emptor. The one exception to that, which courts throughout Ohio have recognized, including this court, is that if there is a claim of fraud, that does not fall within the caveat emptor discussion. I think what it boils down to, it's not a test of evidence as opposing counsel references. You're not looking and analyzing the evidence at the trial court level regarding the summary judgment motion. It comes down solely to whether there is any evidence of fraud in the light most favorable to my clients. In this case, there is a report from Mr. Vovic which talks about things that he discovered that had to exist at the time the property disclosure form was prepared and when those statements were made. People may think that's not a very good case. If you try that case 10 times, you're going to lose 9 of them. But is there a question of fact? That is what the court has to consider. The court, unfortunately, in this case, decided credibility. Just listening to our arguments here, people talking about what was or was not there, not only goes to that fraud issue, but more importantly goes to the sanction issue. In this case, an attorney and his clients are sanctioned where he has information prior to filing suit that in fact fraud took place. And the standard absolutely clear under existing law that no reasonable lawyer could argue the claim. That is the standard. The claim exists under a fraud theory if we can prove it. The law is there though. There is a basis for doing that. So then we move to what evidence was there. In today's world, if we can't believe our own clients unless we have some definite indication that they are not being honest with us, how can you question a lawyer and sanction him or her for that conduct? That is what occurred in this case. Was the legal theory wholly unwarranted? Again, if we believe Vovek, whether you like him or not, if that is true, there's an issue of fact. And the court, again, in this case, interpreted that, which it should not have done. I would ask that the court, again, look at the issue as it relates to sanctions. What is it that my client did, Mr. Whitaker did in this case, that any one of us, anyone within the sound of my voice, what would they have done differently? And even if you would have done something differently, or even if he didn't have a case, say the Vovek report doesn't rise to the level of fraud, that's still not enough. You have to show that he essentially threw all that out the window and brought this claim. Just because you lose a case or you're granted summary judgment doesn't mean the other side is entitled to sanctions. That sanction statute is limited for very specific cases where the conduct of the lawyer is egregious and wrong. This is not that case. So I would ask that the court reverse the granting of summary judgment. I believe if the court does do that and sends it back for consideration on that issue, then the sanction issue likewise has to be reversed, because the court has determined there is an issue of fact and a claim that potentially may not be a great claim, but a potential claim that can be asserted. And with that, we would ask that you reverse both of the decisions in this case. Thank you.
Thank you all for your presentations. The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the date it's released, and the Ohio Supreme Court posts its opinion on its website. Thank you again for your presentation.
Thank you.